All right, so let's go over Section 604 of the Credit Fair Debt Collections Practices Act. It is pretty intense, so let's break it down for you. Permissible purposes of consumer reports, 15 USC subsection 1681B. It says, in general, subject to subsection C, any consumer reporting agency may furnish a consumer report under the following circumstances and no other. In response to the order of a court having jurisdiction to issue such an order or a subpoena issued in connection with proceedings before a federal grand jury, in accordance with written instructions of the consumer to whom it relates. To a person which it has reason to believe, let me scroll down here. A, intends to use information in connection with the credit transaction involving the consumer on whom the information is to be furnished and involving the extension of credit to or review or collection of an account of the consumer, or intends to use information for employment purposes, or intends to use the information in connection with the underwriting of insurance involving the consumer, or intends to use the information in connection with the determination of the consumer's eligibility for a license or other benefit granted by a governmental instrumentality required by law to consider an applicant's financial responsibility or status, or intends to use the information as a potential investor or servicer or current issuer in connection with the valuation of or an assessment of the credit or prepayment risk associated with an existing credit obligation, or otherwise has a legitimate business need for the information in connection with the business transaction that is initiated by the consumer, or to review an account to determine whether the consumer continues to meet the terms of the contract. Executive departments and agencies in connection with the issuance of government-sponsored individuality bill travel charge cards. All right, so basically for court, credit, and to maintain credit. All right, in response to a request by the head of state or local child support enforcement agency or a state or local government official authorized by the head of such an agency, if the person making the request certifies to the consumer reporting agency that the credit report is needed for the purposes of establishing an individual's capacity to make child support payments or determine the appropriate level of such payments. The paternity of the consumer for the child to which the obligation relates has been established or acknowledged by the consumer in accordance with state laws under which the obligation arises, if required by those laws. The person has provided at least 10 days prior notice to the consumer whose report is requested by certified or registered mail to the last known address of the consumer that the report will be requested, and the consumer report will be kept confidential, will be used solely for the purpose described in subparagraph A, and will not be used in connection with any other civil, administrative, or criminal proceeding for any other purpose. Now, so some of y'all going through child support, these things are very important because I don't know about you, but I know tons of people that never get a letter stating that they're going to be using this information for the purposes of child support. Not even tell them that they're even getting their credit information for child support, at all. They don't even get any acknowledgement, any information, or any notice that that's being done. So this right here is a section right here that I believe that the child support enforcement agencies are violating, unless I'm reading it wrong, but it seems to me that the person needs to provide 10 days prior to notice to the consumer whose report is being requested by certified or registered mail to the last known address of the consumer that the report will be requested. And the consumer report will be kept confidential, will be used solely for purposes described in subparagraph 8, and will not be used in connection with any other civil, administrative, or criminal proceeding, or for any other purpose. They don't do that, guys. Hold them accountable to that. That's a breach of the Fair Debt Collection Fair Debt Collections Practices Act, subsection 604. To an agency, number 5, to an agency administering estate plan under section 454 of the Social Security Act, 42 U.S.C. subsection 654, for the use to set an initial or modified child support award. Wow, I didn't even know that child support was really connected to section 604. Through the Federal Deposit Insurance Corporation, FDIC, or the National Credit Union Administration as part of its preparation for its appointment or as part of its exercise of powers as conservator, receiver, or liquidating agent for an insured depository institution or insured credit union under the Federal Deposit Insurance Act or the Federal Credit Union Act, or other applicable federal or state law, or in connection with the resolution or liquidation of a failing insured depository institution or insured credit union as applicable. B. Conditions for furnishing and using consumer reports for employment purposes. Certification from the user. A consumer reporting agency must furnish a consumer report for employment purposes only if the person who obtains such a report from the agency certifies to the agency that the person has complied with paragraph 2 with respect to consumer report, and the person will comply with paragraph 3 or with respect to the consumer report if paragraph 3 becomes applicable. Subsection 2. Information from the consumer report will not be used in violation of any federal or state equal employment opportunity law or regulation. Now, the consumer reporting agency provides with the report or has previously provided a summary of the consumer's rights under this title as prescribed by the Bureau under Section 609C. In general, except as provided in subparagraph B, a person may not procure a consumer report or cause a consumer report to be procured for employment purposes with respect to any consumer unless a clear and conspicuous disclosure has been made in writing to the consumer at the time before the report is produced. The consumer has authorized in writing which authorization which may be made upon document referred in a clause, application by mail, telephone, computer, or other similar means. So basically, you have to employment, you have to volunteer to do that. With child support, they're supposed to notify you. I'm going to put you guys on hold really quick. Hold on. Just 1 second. I'll come right back. All right, guys, I'm back here. So basically, like I said, you have to, for employment purposes, you have to do the application. You actually have to volunteer the information. With child support, when those obligations through the court, they have to tell you that they plan on using it within a certain period of time to let you know that what it's going to be used for, so you have an opportunity to rebut it. All right, conditions, let's go to the scope, section C. Subparagraph B shall apply to a person procuring a consumer report or on a consumer in connection with the consumer's application for employment only if the consumer is applying for a position over which the Secretary of Transportation has the power to establish qualification and maximum hours of service pursuant to the previous provisions of sections 31502 of Title 49, or a position subject to safety regulation by a state transportation agency. As of the time at which the person procures the report or causes the report to be procured, the only interaction between consumer and the person in connection with that employment application has been by mail, telephone, computer, or other similar means. All right, number 3, conditions on use for adverse actions. In general, except as provided in subparagraph B, in using a consumer report for employment purposes, before taking any adverse action based in whole or in part on the report, the person intending to make such adverse action shall provide to the consumer, to whom the report relates, a copy of the report, and a description in writing of the rights of the consumer under this title as prescribed by the Bureau under Section 609C. Application B. Application by mail, telephone, computer, or other similar means. If the consumer described in paragraph C applies for employment by mail, telephone, computer, or other similar means, and if the person who has procured a consumer report on the consumer for employment purposes takes adverse action on the employment application based in whole or in part on the report, then the person must provide to the consumer to whom the report relates, in lieu of the notices required under subparagraph A of this section and under section 615A, within 3 business days of taking such action, an oral, written, or electronic notification. I. The adverse action has been taken based in whole or in part on the consumer report received from a consumer reporting agency. Of the name, address, and telephone number of the consumer reporting agency that furnished the consumer report, including a toll-free telephone number established by the agency if the agency complies and maintains files on consumers on a nationwide basis. 3. That the consumer reporting agency did not make the decision to take the adverse action and is unable to provide to the consumer specific reasons why the adverse action was taken, and that the consumer may, upon providing proper identification, request a free copy of a report and may dispute with the consumer reporting agency the accuracy or completeness of any information in the report. 2. If under clause B1, what's that? 1V, I believe that's 5. The consumer requests a copy of the consumer report from the person who procured the report, then within 3 days of receiving the consumer request, together with proper identification, the person must send or provide to the consumer a copy of a report and a copy of the consumer's rights as prescribed by the Bureau under Section 609(3). All right, scope. Paragraph B shall apply to a person procuring a consumer report on a consumer in a connection with the consumer's application for employment, only if the consumer is applying for a position over the Secretary of Transportation and has established these powers, which we have read that before. Exception for national security investigations. In general, in the case of an agency or department of the United States government which seeks to obtain and use a consumer report for employment purposes, paragraph 3 shall not apply to any adverse action by such agency or department which is based in part or on such consumer report. If the head of such agency or department makes a written finding that the consumer report is relevant to national security in investigation of such agency or department, the investigation is within the jurisdiction of such agency or department, there is a reason to believe that compliance with paragraph 3 will endanger the life or physical safety of a person, result in flight from prosecution, result in destruction of or tampering with evidence relevant to the investigation, result in intimidation of a potential witness relevant to an investigation, result in the compromise of classified information, or otherwise seriously jeopardize or unduly delay the investigation of another official proceeding. You know, guys, this is pretty deep stuff, what they do with your credit report. This is pretty deep. Let's go down to section B. Notification of consumer upon conclusion of investigation. Upon conclusion of a national security investigation described in subparagraph A, or upon the determination that the exception under subparagraph A is no longer required for the reason set forth in such subparagraph, the official exercising the authority in such paragraph shall provide to the consumer who is subject of the consumer report with regard to which such finding was made. All right, a copy of such consumer report with any classified information redacted as necessary. Notice of any adverse action which is based in part on the consumer report. Identification with reasonable specificity of the nature of the investigation for which the consumer report was sought. Delegation by head of the agency or department. All right, this is pretty deep stuff, man. The agencies, these people use your credit report often for national security, child support, work. Everything is attached to this number. Now, from a spiritual perspective, to me, this number will be considered what they call in the Bible the mark of the beast. So, most of us think that we have to continue to be a part of it, but in reality, we really don't. But that's something for another discussion. Now, furnishing reports in connection with credit or insurance transactions that are not initiated by the customer. So you're furnishing a report in connection with credit or insurance transactions that are not initiated by me. In general, a consumer reporting agency may furnish a consumer report relating to any consumer pursuant to subparagraph A or C of section A of subsection A, subsection 3, in connection with any credit or insurance transactions that is not initiated by the consumer, only if the consumer authorizes the agency to provide such report to such person, or the transaction consists of a firm offer of credit or insurance. The consumer reporting agency has complied with subsection E. There is not in effect an election by the consumer made in accordance with subsection E to have the consumer's name and address excluded from lists of names provided by the agency pursuant to this paragraph. Hold up, let's read that again. There is not in effect an election by the consumer made in accordance with subsection E to have the consumer's name and address excluded from a list of names provided by the agency pursuant to this paragraph. You can remove your name and address, guys. And the consumer report does not contain a date of birth that shows that the consumer has not attained the age of 21, or if the date of birth on the consumer report shows that the consumer has not obtained the age of 21. Such consumer consents to the consumer reporting agency to such furnishing. Okay. Limits on information received under paragraph 1, subsection B. A person may receive, pursuant to paragraph 1B only, the name and address of a consumer, an identifier that is not unique to the consumer, that is used by the person solely for the purposes of verifying the identity of that consumer, and other information pertaining to a consumer that does not identify the relationship or experience of the consumer with respect to a particular creditor or other entity. Information regarding inquiries. Very important information. This is what you really want to pay attention to. Information regarding inquiries. This is how one of the ways, to get hard inquiries off your credit report. Except as provided in section 609A, subsection 5, subsection 1681G. A consumer reporting agency shall not furnish to any person a record of inquiries in connection with a credit or insurance transaction that is not initiated by a consumer. Section D is reserved. Section E, election of consumer to be excluded from lists. Now, you have the right to elect to be excluded from lists. In general, a consumer may elect to have the consumer's name and address excluded from any list provided by a consumer reporting agency under subsection C1B in connection with the credit or insurance transaction that is not initiated by the consumer, by notifying the agency in accordance with paragraph 2 that the consumer does not consent to any use of a consumer report relating to the consumer in any connection with any credit or insurance transaction that is not initiated by the consumer. Basically, you can copy and paste that and write a letter and send that in. Manner of notification. A consumer shall not notify a consumer reporting agency under paragraph 1 through the notification system maintained by the agency under paragraph 5, or by submitting to the agency a signed notice of election form is issued by the agency for the purposes of this subparagraph. So you can do it through the system, or you can submit to them a signed notice of election form. Let's open up another window and say, let's see, signed notice of election form PDF. Let's see what it looks like. Political subdivisions, registration reporting, sample hospice form. I spelled something crazy. Did I shit? Well, here we go. State Board, informed consent, COBRA. Let's see. credit. FDCPA. All right. I don't see the form. So let's go back to the act. I'm sure it'll pop up. Let me hold on, guys. Let me put you on pause real quick. All right, so I'm back. So let's go back to section E here. It says, in general, a consumer may elect to have the consumer's name and address excluded from any list provided by a consumer reporting agency under subsection C, subsection 1, subsection B, in connection with a credit or insurance transaction that is not initiated by the consumer. So they can't just come up and get your information when you elect not to be a part of the list. So what you got to do is by notifying the agency in accordance with paragraph 2 that the consumer does not consent to any use of a consumer report relating to the consumer in connection with any credit or insurance transaction that is not initiated by the consumer. Very important. Manner of notification. A consumer shall notify a consumer reporting agency under paragraph 1 through the notification system maintained by the agency under paragraph 5, or by submitting to the agency a signed notice of election form issued by the agency for the purpose of this paragraph. So I guess I couldn't find it on the internet, but I probably will find it. Each individual agency appears to have, looks like they should have their own election form. All right. And B, provide to the consumer a notice of election form if requested by the consumer not later than 5 days after receipt of the notification of election through the system established under paragraph 5. In the case of a request made at the time, the consumer provides notification through the system. Effectiveness of election. An election of a consumer under paragraph 1 shall be effective with respect to a consumer reporting agency beginning 5 business days after the date on which the consumer notifies the agency in accordance with paragraph 2. Shall be effective with respect to a consumer reporting agency. Subject to paragraph C, during the 5-year period beginning 5 business days after the date on which the consumer notifies the agency of election, in the case of an election for which a consumer notifies the agency only in accordance with paragraph 2A, or until the consumer notifies the agency under subparagraph C, in the case of an election for which a consumer notifies the agency in accordance with paragraph 2B. They really try to confuse you and spin these words, but it's very simple, guys. You have a right not to participate. All right. And C, shall not be effective after the date on which the consumer notifies the agency through the notification system established by the agency under paragraph 5 that the election is no longer effective and shall be effective with respect to each affiliate of the agency. Let's talk about this notification system. Let's learn about it. Gotta dig deep sometimes. In general, each consumer reporting agency that under subsection C1B furnishes a consumer report in connection with a credit or insurance transaction that is not initiated by the consumer shall establish and maintain a notification system, including a toll-free number which permits any consumer whose consumer report is maintained by the agency to notify the agency with appropriate identification of the consumer's election to have the consumer's name and address excluded from any such list of names and addresses provided by the agency for such a transaction, and subsection I, published by not later than 365 days after the date of enactment of the Consumer's Credit Report Reform Act of 1996, and not less than annually thereafter. In a publication of general circulation in the area served by the agency, a notification that information in consumer files maintained by the agency may be used in connection with such transactions, and the address and toll-free number for consumers to use to notify the agency of the consumer's election under Clause 1. Establishment and maintenance as compliance, establishment and maintenance of a notification system, including toll-free telephone number, and publication by a consumer reporting agency on the agency's own behalf and on behalf of any of its affiliates in according with the paragraph is deemed to be compliance with the paragraph by each of those affiliates. All right, guys, we're going to be reading a little bit down here, but we're going to get there. Notification by agencies that operate nationwide. Each consumer reporting agency that complies and maintains files on consumers on a nationwide basis shall establish and maintain a notification system for purposes of paragraph 5 jointly with other such consumer reporting agencies. So they got to be joint. You notify one, you notify all. All right? Certain use or obtaining of information is prohibited. A person shall not use or obtain a consumer report for any purposes unless the consumer report is obtained for a purpose for which the consumer report is authorized to be furnished under this section, and the purpose is certified in accordance with Section 607, subsection 1681E, by a prospective user of the report through a general or specific certification. Protection of medical information. Limitation on consumer reporting agencies. A consumer reporting agency shall not furnish for employment purposes or in connection with a credit or insurance transaction a consumer report that contains medical information other than medical contact information treated in the manner required under Section 605A(6) about a consumer unless, if furnished in connection with an insurance transaction, the consumer affirmatively consents to furnishing a report. If furnished for employment purposes or in connection with the credit transaction, the information to be furnished is relevant to process or affect the employment or credit transaction, and the consumer provides specific written consent for the furnishing of the report that describes in clear and conspicuous language for the use for which the information will be furnished, or the information to be furnished pertains solely to transactions, accounts, or balances relating to debts arising from the receipt of medical services, products, or services where such information other than account status or amounts is restricted or reported using codes that do not identify or do not provide information sufficient to infer the specific provider or nature of such services, products, or devices as produced in Section 605A. Limitations on creditors, except as permitted, pursuant to paragraph 3, subsection C, on regulations prescribed under paragraph subsection 5, subsection 8. A creditor shall not obtain or use medical information other than medical contact information treated in the manner required by Section 605A pertaining to a consumer in connection with any determination of the consumer's eligibility or continued eligibility for credit. Actions authorized by federal law, insurance activities, and regulatory determinations. I mean, this is good stuff here, guys, but this is relating to insurance and health, which I think, it definitely should be read, but we're almost down there, so we might as well read it. All right. Actions authorized by federal insurance activities and regulatory determinations. Section 603D, subsection 3, shall not be construed as to treat information or any communication of information as a consumer report if the information or communication is disclosed. In connection with the business of insurance or annuities, including the activities described in Section 18B of the Model Privacy of Consumer Financial and Health Information Regulation issued by the National Association of Insurance Commissioners as in effect on January 1st, 2003, for any purpose permitted without authorization under the standards for the individuality identifiable health information promulgated by the Department of Health and Human Services pursuant to Health Insurance Probability and Accountability Act of 1996, or referred to under Section 1179 of such act, or described in Section 502E of Public Law 106-102. All these things we need to break down a little bit more. Or excuse me, as otherwise determined to be necessary and appropriate by regulation or order by the Bureau of the applicable state insurance authority with respect to any person engaged in providing insurance or annuities. Limitation on redisclosure of medical information. Any person that receives medical information pursuant to paragraph 1 or 3 shall not disclose such information to any other person, except as necessary to carry out the purpose for which the information was initially disclosed, or as otherwise permitted by statute, regulation, or order. Regulations and effective date for paragraph 2. Paragraph 2, I think I got to read up. Paragraph 2, regulations require the Bureau may, after notice and opportunity for comment, prescribe regulations that permit transactions under paragraph 2 that are determined to be necessary and appropriate to protect legitimate operational, transactional risk, consumer, and other needs, and which shall include permitting actions necessary for administrative verification purposes, consistent with the intent of paragraph 2 to restrict the use of medical information for inappropriate purposes. See CFR parts, those numbers 41, 222, 232, 334, 571, 717, 70 Fed Reg, 70664, 112205. Coordination with other laws. No provision of this subsection shall be construed as altering, affecting, or superseding the ability of any other provision of federal law relating to medical confidentiality. Now, I'm going to roll back up here, guys, because this is a pretty good section. We've learned a lot in the past half hour about this. I've basically read it for you. But it seems like, like I said, you can opt out of these things. Now, permissible purposes of consumer reports. A lot of this stuff you got to have your consent. And if they do not have your consent, you're supposed to be notified and give an opportunity to rebut it. They can't just go in there and take your information off these credit reports. If so, it's a violation of the Fair Credit Reporting Act, subsection 604. When it comes to inquiries, hard inquiries, they're supposed to follow the process. So you can use subsection 604 and you fill out that document that we discussed earlier. You call them up and ask them how to get that document. So that's pretty much it, guys. And I want to thank y'all for tuning in. Thank y'all for paying attention, but there's a way out. You just got to read it. Thanks a lot. Have a great day. Be like water, my friends. Be like water.